Well, I'm from a law firm called Brabners with offices in Liverpool and Manchester, so I've had a quick drive down. It's not as doom and gloom as the immigration talk, you'll be pleased to know, but it isn't as interesting as the immigration talk either, so I apologise if it's slightly more tedious than the talk you've had already. I'm going to be looking at IP initially, and then looking at data protection, which is definitely the dullest part of the talk. I think it was summed up with a little soundbite in the morning session, but in slightly broader terms, I had a quick look at the Arts Council kind of assessment of Brexit when it first came out in 2017 in their research of their various stakeholders, and perhaps unsurprisingly, it was found that the majority of stakeholders had a negative perception of Brexit. And they've actually been a bit polite in their summary here when they said a majority stated they were not able to give any potential advantages arising as a result of Brexit. In actual fact, it was 95% of the respondents couldn't find any potential advantage from Brexit. So whilst we're meant to be as neutral and non-political as possible, I take that in mind as the audience, and I certainly, from that earlier session, can see why there'll be significant concerns. The research that was done highlighted the three key concerns were additional barriers to trade that were going to be created by it, funding concerns, especially for those parts of the Arts Council that are funded from the EU, and as we've just heard, the freedom of movement being probably the most significant concern. And actually, regulation areas such as IP and data protection barely featured at all in the Arts Council guidance. So it's not a massive issue in terms of Brexit. There are some changes. They don't really apply sector specific, so they may well not apply to your day-to-day business, and hopefully to a certain extent that's the case. So we're here now because of the drive for Get Ready for Brexit. In particular, I'm looking at the no deal scenario, which we may well find ourselves in on the 31st of October. We may also find ourselves in that same position in a year's time, because one of the big differences between the deal that's currently on the table and the previous deal that Theresa May had negotiated was that her deal stated that if we hadn't reached an agreement on the trade arrangements at the end of the transitional period, the backstop would apply, the dreaded backstop that no one wanted. Well, that's completely gone from the current deal that's on the table, so we have until a transitional period if a deal is agreed in the next 2 weeks, we'll then have a transitional period until the 31st of December 2020, but if no arrangement is agreed by that point, we are back to the no deal scenario. So this, what follows is equally applicable if we do agree a deal in the first instance, enter into transitional period, and then don't agree that deal by the 31st of December 2020. And it's also been, the last time I gave this talk, the day before, one of my colleagues had been at a Brexit briefing with the Ministry of Justice, and they indicated that they felt it was going to take 6 years to negotiate a new trade agreement. So I'm not sure how that 31st December 2020 deadline would ever be met. Just to touch briefly, if we do remain, there are absolutely no changes other than the fact that will probably be on a remain and reform basis. But again, from an IP perspective, I wouldn't expect any changes. As I say, if there is a deal, we'll have a transitional period until the 31st December 2020, and there will be no changes until that point. But if we don't agree anything else at that point, then what I'm about to say will apply as a no deal scenario. So looking at the particular IP areas, I'm focusing on copyright and trademarks. Now, copyright is going to be most relevant to you guys, copyright throughout the whole of your sector. And the good news is that actually the majority of our copyright legislation is not EU-based, it's international-based. So there is actually very little change from an EU perspective. Copyright is protected by the Berne Convention, which allows your rights to be enforced in 182 countries around the world. You've got the Rome Convention for the protection of performers, producers of phonographs and broadcasting organisations, which are going to be relevant to you guys. You've got WIPO rules, which again, international treaties, WIPO copyright treaties, and you've got something called the trade-related aspects of intellectual property, the TRIPS agreement. All of those will remain entirely in place, so there's absolutely no change. The only thing that we won't be getting the benefit of if we leave is the EU Copyright Directive, which is currently being negotiated, and the one benefit that that would have had is a digital single market, but at the moment that's not something that we can really think about anymore, because we won't get the benefit of that when it comes in place, and that essentially means that anything digital or online would benefit from one legal system, but outside of that we won't be part of that if we're not in the EU anymore. The things that will change from a copyright perspective, and probably the biggest issue for your sector, I think, is collective management. So, for example, all of your collecting societies, where you've got PRS in the UK. At the moment, PRS has the ability to collect for European-wide rights. Going forward, it won't automatically have that right under the legislation. You'll need to check that whoever your collecting management societies are, that they do have the rights to collect for EU, and vice versa. They've got the rights to collect for the UK if you're dealing with someone outside of the UK. So that's probably going to be the biggest change, just to make sure that when you're paying your royalties, you are getting the right coverage for those rights. There's something called sui generis rights, which are database rights. Probably won't be particularly relevant, but we will no longer have the benefit of an EU-wide database right. We're creating our own UK database right, but that will only be enforceable within the UK and will only relate to databases created in the UK. The portability of online services, this is kind of part of the digital single market concept. So at the moment, the law was changed quite recently so that when you accessed your Netflix account, or when you bought a Netflix account in the UK, you could access it in France and you wouldn't have any extra costs. That's the portability of the online services, the freedom of movement of services. That all goes. So just because you've got the rights to access online rights, so maybe it's music content, if you're using a Spotify type account to get your music, don't just automatically assume if you can access in the UK that you'll be able to access it anymore in the EU. So again, you'll need to check your rights, your contracts, to make sure that it covers the whole of the EU as well as the UK, or the specific countries that you want to be moving into. Less relevant, I think, for you guys, but the country of origin principle for copyright clearance in satellite broadcasting, that goes, and that effectively means that anyone in the EU, if there was a broadcast outside of the UK laws would apply. Well, that would no longer be the case, and if we are broadcasting stuff that is from an EU country, then the EU laws will apply rather than the UK laws. Orphan works, so this is if you're using works where you're not entirely sure who the copyright owner is, or whether there is still copyright in it. There is a current system in place whereby there is a huge directory held by the EU Intellectual Property Office where you can identify what rights are out there, and you can pay a license for that. We will no longer be able to benefit from that system because we will be outside of the EU. The UK have said they were going to implement their own system, and they are going to use the EU's database for the same purposes. And it's effectively the UK government has a body which collects a notional license so that if the owner of those orphan works ever appears, then they can get the benefit of those license fees. Outside of that, if for whatever reason you've got a work and you're not sure who the owner is, then there is a potential, if you don't get the right to use it, for a damages claim further down the line. One other law that will slightly change is something called the Marrakesh Directive. I don't know if this is something that you deal with often, but it allows accessible formats of rights to be transferred throughout countries in the EU. So, for example, sight impaired or audio impaired versions of works that are being performed. At the moment, it wouldn't be an infringement of the original work to do that throughout the EU, but outside of the EU, we will no longer be part of the Marrakesh Directive, so something else would need to be put in place to cover for accessible formats being distributed outside of the UK. And the other big change will be an enforcement of your rights. So at the moment, if there was an infringement of your rights, you could bring a claim in the UK courts and you can get a EU-wide injunction. once we're outside of the EU, you won't be able to get EU-wide injunctions from UK courts, and likewise an EU court won't be able to give an injunction over the UK. So it's going to mean potentially more expensive litigation. If you've got infringements in the UK and somewhere else within the EU, you'll need to bring 2 cases rather than just 1. Something that wasn't that relevant the last time I gave this talk, but maybe if you are, particularly if you are protecting your own trademarks and brands, that is going to be a significant change from the IP perspective. At the moment, we have UK trademarks and European Union trademarks. We always recommend that clients file both, but usually from a cost perspective, they will just file, if they've got EU-wide trade, they will just file in the EU, because currently the EU covers the UK. Obviously, when we leave, that will no longer be the case. The UK will no longer be part of the EU trademark. The UK have actually very helpfully set out the legislation quite clearly, so we do know exactly what the case will be once we leave. And what they've said is that every registered EU will be cloned into the UK database. It will be called a comparable trademark EU. So if you do already have EU trademarks, you don't need to do anything. It will be automatically turned into a UK right, and you'll just have to renew it in the normal way as you would do a UK trademark. This is going to be done for free. It's going to be automatic unless you opt out, although I'm not sure why anyone would opt out. They would just simply not renew when it came up for renewal. There was a few nuances on that. At the moment, if you've got an EU trademark which is due to expire on the 1st of November, it's currently renewable, and so and you can renew marks within the 6 months of it about to expire. If you have renewed an EU trademark that is due to expire after the 31st of October, but you've already renewed it, that renewal won't benefit the UK. That mark won't that renewal won't apply to the UK, and you'll have to pay extra UK renewal fees when the renewal date comes up. So that's an additional cost, not significant cost, but it's an additional cost that we'll need to factor in. And if you've got trademark applications in place, but they're not actually granted, they've been opposed or they're going through the process, they will not automatically be cloned into the UK database. What will be given is a 9-month grace period, starting on the date we leave, to reapply for a UK right, but to benefit from the dates of the original EU trademark. And that's going to cost the same, the normal cost for filing a UK trademark application. So there's an additional cost there if you've got applications which haven't yet been registered for trademarks. That then has a knock-on effect if you're doing clearance of trademark rights. So if you've got, you're creating new content, or you've got a new brand, and you want to make sure that you're not infringing someone else's rights that already exist. At the moment, when you do a clearance in the UK, you would normally search both the UK and the European Union trademark registers. Now, theoretically, once we're outside of the EU, we'll no longer need to search the EU trademark if we're only trading in the UK. However, for a period of at least 9 months after we leave, we will still need to review the EU trademark database on the basis that any application that was made prior to the leaving date could, at some stage, become a UK trademark 9 months later. So that will affect clearance searches for the next 9 months to the extent that you do them on your trademarks. I think the key area for your sector will be ensuring all of your contracts cover you. So if you're touring outside of the UK, make sure all of the countries that you are going into, you've got the rights permitted to use the works in those countries. If you've already got existing licenses in place and they refer to the EU and they don't expressly make any statement to the contrary, they don't list the countries, then the UK has actually drafted the legislation to say that a license that refers to the EU will include the UK even after the Brexit date. So that has been considered, but you should still check contracts where you've licensing in EU rights just to make sure that it doesn't have an express statement actually preventing that, and making sure going forward that when you negotiate contracts and license rights that you're covering the specific countries that you need. So EU will no longer cover the UK going forward. One other small thing, if you do have EU trademarks, UK lawyers will no longer be able to be representatives for EU trademarks if we leave without a deal, so you'll need to ensure that you've got EU representatives as well to help you with that. Most UK law firms will be putting in place a effectively a service company, so they'll still be doing all of the work, but it just adds an extra cost because you've then got to pay kind of service fees for the European advisors as well. And then something that's not really trademarks, it's more of a contractual right than an IP right, but domain names. So if you've actually currently using a .eu domain name for any of your websites, the .eu regulations stipulate that you have to have EU domicile or residence in order to have a .eu domain name. So if you don't have a establishment in a EU country, and you currently have a .eu domain name, there is a significant risk that .eu domain name will become invalid. And what they've indicated they will do is they will issue letters on the Brexit date to anyone with a .eu domain name and say you need to re-register your address with an EU address, and if you can't do that, then your .eu domain name will lapse. So anyone who uses a .eu domain name will need to think about if they need to register a new domain name which doesn't come under the .eu process, or whether they need to have an establishment in the EU to cover that point. The other thing that the UK government has done to minimise disruption, they've unilaterally determined that in the case of a no-deal Brexit, they will for a temporary period, which has not been stipulated, they will apply the exhaustion of rights principle in the UK. Now, the exhaustion of rights principle, as it currently works, is any product or that is put on the market in the EU, the rights are exhausted for the whole of that EU. So that product, so if I put something on the market in the UK, it can be bought and then sold anywhere in the EU. That's the way back when the big case was when Tesco's were importing Levi jeans that were being sold in Lithuania at dirt cheap prices. They were importing them into the UK and be able to sell them at a cheaper price than the UK distributors of Levi jeans, and that's the freedom of movement of goods via the exhaustion of rights principles. The UK have said in order to minimise disruption to business, they will continue to apply exhaustion of rights principles, so you can still import goods that have been placed on the EEA market into the UK without infringing anyone's intellectual property rights. So that is a benefit to importers of goods and users of goods. It's a negative to people who have UK rights because those UK rights can be circumvented by putting those products in the market and getting them from Ireland and bringing them across the border, for example. But that probably won't affect your sector that significantly, but it is worth bearing in mind as a change that's going to happen generally. And that's all I was going to cover from an IP point of view, unless anyone's got any additional questions. And looking around, I don't think so. And it adds on to my point about it's not the doom and gloom of the immigration talk, which I totally realise is of a far greater concern to you than the IP side of things. So moving on to the even less exciting topic of privacy and data protection. This is dull at the best of times, even when I'm not talking about Brexit. So when doubling up and keeping you all from lunch, hopefully I'll do this nice and quickly, because again, there's not a vast amount of difference. There's probably two key points which I'll get onto, which may affect you, particularly again where you're touring in the EU. But crucially, there's a lot that's not changing. The EU regulations, the General Data Protection Regulations, the GDPR, which you've almost certainly have heard of, are now UK law. They will still be in place after we leave the EU, so they will all still apply. We've got also e-privacy regulations already implemented in the UK. They won't change. The EU is currently negotiating a new directive, which actually meant to be agreed a couple of years ago, but hasn't been. So the new EU directive, if we leave without a deal, won't apply to us, but the UK regulations are already pretty tight anyway. This will mean that there's going to be no change at all to use and transfer of data within the UK. The EU regulations will still apply to any use or transfer of data of EU citizens. So we can't just ignore any EU rights. All of the EU laws will still apply to EU citizens' data. And the same principles apply to any transfers of data from the UK going to other countries. All of the rules that we have in place at the moment will still apply when we leave. So those things aren't changing. What is changing is that the UK is going to become a third country, not third world country, but it might feel that way. And there are really three key areas that this will impact upon from a data protection point of view. You may need to appoint an EU representative, similar from the trademark point of view, and I'll get onto that in a second. If you're using EU citizens' data, or you're touring within the EU, you may end up dealing with EU supervisory authorities. The UK one is the ICO, the Information Commissioner's Office, but if you're dealing with data of EU citizens, or if you're dealing with data outside of the UK but in another country in the EU, then you might need to be dealing with their supervisory authorities. And there may be issues in terms of transfers into the UK of data. So if you've got data transfers coming into you from any EU country, you need to have a look at what you've got in place for that, and you might need to have additional contractual terms or more red tape. So the benefits of having less bureaucracy may not actually apply to this point. You might actually get more red tape when we leave. From an EU representative point of view, it's a little bit similar to the trademark point and the domain name point. If you are a UK organisation and you have no establishment elsewhere in the EEA, and the assumption is when we leave without a deal from the EU, we'll automatically also leave the EEA. That's been the position stated by the government, and also the position stated by the EU. And if you are offering, probably in your case, services to EEA individuals, you may need to appoint an EU representative. So I think this is going to be specifically for those of you who are touring and are spending a lot of time in the EU. You may well need to have an EU representative to deal with your data protection issues. The only exemption to that is if the use of personal data is occasional and low risk and doesn't involve sensitive data. Sensitive data is stuff like health records, which again is probably information that you will have if you're doing tours of shows. So that's where I think there will need to be some consideration. If you are touring for extensive periods in the EU, you'll probably need an EU representative to deal with your data protection issues, and that can be an internal person, or it can be an external counsel like a lawyer. We'll also have to deal with EU supervisory authorities in relation to any EU data citizens, or if you are dealing with data in the EU. So currently the GDPR allows us to have a one-stop shop system, so that if you are dealing with any EU data in the UK, the Information Commissioner's Office, the ICO, can deal with all the issues, so any complaints, compliance, any fines. You won't be fined in every single EU country, it will just be one supervisory authority that would deal with it. If we leave the EU, the ICO will no longer be a competent authority under the EU rules. So if there is a breach, for example, and your data includes both UK data and data of EU citizens, theoretically you could get investigated and fined by both a UK office and by an EU office. And if you're dealing predominantly with EU data, or you're dealing with that data in an EU country, then it's likely to be an EU supervisory authority rather than the UK that you'll be dealing with. So that's something, again, more red tape, more concerns. Something to bear in mind if you are dealing with EU data, that the ICO will no longer be responsible for that data. So the other big change, which again probably won't affect you that much, but that because we are a third country, transfers, at the moment if you transfer data between EU countries, that's allowed under the GDPR. Once we leave the EU, we will be considered a third country, and therefore any transfers of data into the UK will be considered a restricted transfer. And what that means is that you need to have additional safeguards in place in order to make that transfer lawful. And those safeguards, there's a number of different ways you can put those safeguards in place. The primary one is something called an adequacy decision, which is where the EU Commission say, actually, no, this country has has adequate data protection rules in place, so we will grant an adequacy decision. Now, you'd expect that because we are leaving and adopting all of the GDPR regulation, we will be considered to be a adequate country. However, that adequacy decision isn't something that can be done automatically. It takes time, and that could easily be a year-long process before we actually get an adequacy decision granted. So we can't rely on that from day one. Then the next two exceptions are something called the standard contractual clauses and binding corporate rules, and those are going to be probably the main two things. So, for example, if you have data being transferred into the UK, you need to make sure you've got a good contract in place which has a set of clauses which are drafted by the EU, they're called standard contractual clauses, added as a schedule to the agreement, and you need to make sure that one, you've got them in your agreement, and two, you comply with them. So a little bit of added red tape, but for those companies who operate under a best practice data protection compliance anyway, that's not a huge amount of difference in terms of what you're currently doing. Binding corporate rules are something that applies if you've got lots of different corporate entities throughout the EU. So if you've got a French office and a UK office, then you, rather than having a specific contract in place between you, you can have binding corporate rules, which are kind of like corporate policies. For that to be a perfect safeguard, it actually needs to be signed off by a supervisory authority, and the UK will no longer be able to sign off that binding corporate rule. You'll need to get it signed off by an EU supervisory authority, but that's something there that can be used. And you can also have some exemptions for some transfers of data where you've actually got the data subject's consent, or it's for the purpose of performing a contract in relation to that data subject. So that's just a case of making sure that when you're obtaining the data that the necessary consents have been obtained, or that the contract allows you to transfer the data into the UK. But on top of that, we would always recommend having contractual clauses and making sure you've got good agreements in place where you're transferring data in. The other thing to factor in when you're transferring data into the UK, if it's a supply of services, if you're paying for the transfer of data, there may well be VAT considerations to think about as well. But that's a VAT point rather than a data protection point. And just to explain, in summarise what types of transfers are caught and not caught. So non-restricted transfers are any transfer from the UK to an EU or EEA country, that's fine. Transfers from the UK to a third country that has an adequacy decision, that's fine as well. And currently, transfers from the UK to the USA is also allowed. The USA does not have an adequacy decision as such, but it's got something called Privacy Shield, and it's currently going through the EU Commission as to whether the US Privacy Shield system is compliant with GDPR. Their previous system, which was called the US Safe Harbor, failed, and there's a good chance that the US system will also fail. So transfers to the USA, watch this space, but otherwise they're non-restricted transfers, and the restricted transfers are anywhere coming into the UK, and the UK going to any other third countries that aren't the EEA and don't have an adequacy decision. I think that's me. So a lot less doom and gloom than immigration, and hopefully a lot less relevant to you guys, but if you've got any questions, I'm more than happy to answer them.
Someone must have one question.
I've got a question. In our applicant tracking system that we use, we have somebody in finance, for example, applying for a role in the UK. Does that constitute a transfer of data into that system? Do I need to contact our supplier?
So that will be a transfer of data. In that case, you should probably either be getting consent, or you'll be arguing that that's for the performance of a contract, or to enter into negotiations for the performance of a contract, the contract being the employment contract or whatever the contractual position between you and the French. So an exemption will apply to that. But to the extent that you're getting data regularly transferred from providers in France into the UK, you should make sure that the contracts that you have in place with them are strong and ideally include the standard contractual clauses. since GDPR, the majority of law firms that distribute kind of standard data processing agreements pretty much include and incorporate all of those clauses anyway.
The ownership of data, the data companies, like Amazon, if they were non-British, would that affect our
Not really, because the way the legislation is drafted, it doesn't matter where you are. If you are dealing with UK data, then the UK laws will apply. If you are dealing with EU data, then, well actually, the twofold. If you're in the UK, then UK laws will apply, full stop, regardless of what date, for worldwide data. If you're not in the UK, but you're dealing with UK data, then the UK laws will still apply. There may be difficulties in enforcing the UK laws against people who aren't resident in or domiciled in the UK, and so vice versa. If you're a UK company and you're using EU data, then you're caught by the UK laws, but you're also caught by the EU laws as well. So it doubles up. So you're not, by having ownership outside of the UK, you don't fall outside of the UK system. You might have two different systems apply. Potentially three. So if you've got a US owner, they'll be subject to the US laws on data protection. If they're controlling data in the UK, then you'll be subject to the UK laws. And if that data includes the data of EU citizens, it will also be controlled by the EU laws. So you could have three supervisory authorities all looking at you, and potentially, if there's a breach, all three of them fining you. So the perfect example of that, and the figures won't be the same, but Google just got fined by the US £6 billion. Was it Google or was it Facebook? I think it was Google. £6 billion. They've settled it at $5 billion. You can please know, good compromise there. But they're also being investigated by the French. So where you've got different territories applying, you could end up being fined significantly twice.
So I think if a company kind of use MailChimp or one of those item companies that kind of may be based in, say, Dublin, would you have to, as a company, think about anything?
Yeah, I mean, so people do this all the time anyway without thinking. It's quite often, quite a lot of them have servers outside, Amazon Web Service. Quite a lot of servers are based in India. So already, quite often when you use these third-party services, you need to check where their servers are based. Prior to the GDPR coming into force, they used to charge extra. So Amazon, for example, said, well, we can ensure that it's all kept within our EU servers, but you have to pay a premium for that purpose. Since GDPR, I think, because so many companies said, we're not paying a premium, this is just, you have to have this in place, that Amazon, I think, have dropped that point in their services. But you do need to check where you're using third-party services, where their servers are based. And if their servers aren't based within the EEA, then that is going to be an issue. If they're based in the EU, then it's going to be okay, because that's not going to be a restricted transfer for you. In the UK, the system will allow it. The UK could change its laws again and say, no, actually, we're not going to allow transfers to EU places, but I'd be very surprised if they did that.